legislature, Congress isn't going to be able to stand in the way of an amendment. After several weeks, the Constitutional Convention presented its resolutions to a committee headed by John Rutledge, later on Chief Justice of the United States Supreme Court, and they drafted a first draft of the Constitution. And they provided for an amendment process by convention. 2/3 of the states would demand a convention. Congress would have to call one, and then the convention would meet. It would draft the amendments, and it would also approve the amendments. So later on in Philadelphia, there were 2 additional amendments offered, 2 additional changes offered. One by Elbridge Gerry said, we don't think that a convention should have the power to simply adopt amendments itself. They've got to be approved by the states. And the other delegates agreed. Secondly, Alexander Hamilton said, Congress ought to be able to propose an amendment too. And the delegates agreed with that too. But when they put Hamilton's language in the Constitution, it looked too much like Congress was going to have control over the amendment process. And so 2 days before the convention adjourned, George Mason of Virginia stood up and said, look, this government might become abusive. Let's establish a way of bypassing Congress. Let's let the states bypass Congress. And once again, the delegates unanimously agreed. The result was the creation of this body of type. Now, I might say to you, look at this and memorize it instantly, but the usual effect of doing that is something like this. So we're not going to read Article 5, but what we are going to do is just break it down a little bit. It breaks down into 4 sections. Proposal, ratification, mode of ratification, and then things that can't be done. What are the things that can't be done? Well, there's one in particular. You can't deprive Wyoming of its equal representation in the Senate without the approval of Wyoming. That's an unamendable thing. That's outside the scope of Article 5. So those are basically the 4 sections. We're going to be concentrating on proposal. The other thing to understand about Article 5 is that there are roles for different assemblies of people in Article 5. State legislatures have a certain role. Congress has certain roles. The Convention for Proposing Amendments has certain roles. State ratifying conventions do also. And the powers to perform those functions are given by Article 5. In other words, Article 5 is the same way that enumerated powers are granted by the Constitution to Congress. So, what are the enumerated powers of the Convention for Proposing Amendments, and what is it? Remember, just a little reminder here, before I get into more history. First, a convention. Convention is an ad hoc group. That is to say, it meets, it addresses a problem, and it adjourns. That's traditionally how the word convention has been used in our constitutional history. Convention is not a legislature. Convention has one job to do, and then they adjourn sine die. It is like a task force. Think of a convention as a task force.
Okay.
At the time the founders drafted the Constitution, there had already been many interstate conventions, and before that, intercolonial conventions. The first one isn't even on this list. It was held in New York City in 1677. By the time we declared independence, there had been about 20 intercolonial conventions. And then in the years between 1776 and the time the Constitution was written, there were 11 more. So that meant when the Constitutional Convention met, it was the 31st meeting of its kind. It was the 31st Convention of States or Colonies. And from all of these meetings, you develop certain procedures, certain protocols. But when the Wyoming legislature comes into session, after being out of session, it doesn't reinvent all of its rules. It doesn't reinvent all of its protocols. It follows precedent. Might make some changes, but basically follow. Same thing with these conventions. And the founders themselves, many of them had been to 1, 2, 3, 4, 5 conventions. The guys that are on the slide here are just members of the Constitutional Convention who had prior experience with conventions of states. There were many other founders like Patrick Henry, who wasn't at the Constitutional Convention, who also had that kind of prior experience. So it's like, we read the Constitution and we see language like this. The writ of habeas corpus shall not be suspended. Well, does the Constitution write out explanations as to what the writ of habeas corpus is? Or trial shall be by jury. Does the Constitution explain in detail what a jury trial is? No. Everybody understood this at the founding era, and we can learn what a trial by jury is, and what a writ of habeas corpus is, or what a convention for proposing amendments is, simply by studying the history. There are a few other myths I've already mentioned. One, that the Constitutional Convention exceeded its authority. Also, some of you may have seen a little blurb in which James Madison is quoted as opposing an amendments convention. I can assure you that that is taken grossly out of context, and that in fact, at various points in his life, Madison recommended amendments conventions. Now, where did I get all this information? Well, one way I got the information is by reading the debates over the Constitution, the ratification record. I'm going to flash a few examples on the screen. We're not going to read them closely, but these examples they all come from the debates over the ratification, and they show you how the founders thought that state legislatures and the states were central to this process. Underscoring of the word state. I like this one in particular. Tench Coxe was a really influential writer in favor of the Constitution, possibly more influential than the Federalist Papers at the time. And I love this line. 3/4 of the states can introduce the amendments into the Constitution, although the President, Senate, and Federal House of Representatives shall be unanimously opposed to each and all of them. This is the way of bypassing Congress. This is a state-based process, something I didn't know before I got into this. I also looked at founding era legislative resolutions. Founding era resolutions from states like North Carolina, Rhode Island, Pennsylvania, New York, Virginia, all referred to this particular process as involving a convention of the states. And there was a Supreme Court opinion that's described this process as a convention of the states. Not one of the law professors whose articles I read in advance had ever uncovered the Supreme Court opinion. It's really hard to do. All you have to do is enter the word convention in a database and it pops up. Database of Supreme Court opinions. Never done that. In addition, there's been a great deal of Article 5 practice after the founding. A lot of application campaigns, the ratification of the 21st Amendment by state conventions, and a lot more inter-conventions of states. Some national, like the one in 1861 in Washington, D.C. was a national convention of states. Some of them just regional. Look at the last two on the list. The last two on the list were held among western states for dividing up the Colorado River water. Wyoming sent commissioners to both of those conventions. Wyoming has, in fact, already participated in 2 conventions of states, actually 3 conventions of states. Come back to that in a minute. In 1861, with Civil War impending, Virginia called a convention of the states, chaired by former President John Tyler. And what did it do? It recommended a constitutional amendment. It was a dry run in virtually every particular for a convention for proposing amendments. We could still use those rules today. It didn't have Article 5 powers, so it couldn't propose to the states. It had to propose to Congress. But that was the only difference. That was the largest convention of states ever held. And then Wyoming, the 3rd convention of states that Wyoming has participated in, was a year and a half ago in Phoenix, Arizona. Anybody recognize any of the people in the photos?
Ken Ivey.
Yeah, there's a Representative Ken Ivey from Utah. He's all the way over to the right. And on the left is David Goldenshoe from Georgia. And Kelly Townsend there from Arizona. She's the president. This is the first convention of states ever to include women commissioners. And of course, Kelly Townsend is the first woman to ever preside over a convention of states. I don't know who the other person is. So when people tell you there are no precedents here or everything's open, no need for confusion. Okay, I'm going to summarize this part of the presentation with just these 10 key facts. Number 1, as Nathan already said, the purpose of this procedure, it can be used for any amendments, but the real purpose was to deal with the situation such as we have today, federal dysfunction that Congress refuses to deal with. Secondly, the Constitution is the source of the power for the convention for proposing amendments, and as its name indicates, it can only propose. Thirdly, it is not a meeting of individual delegates. It is a meeting of delegations of commissioners from the individual states, or more precisely from the state legislatures. Next, if 34 states, or 2/3, apply for a convention on a particular topic, Congress must call it. That's clear from the language, and everybody agrees with that. The state legislature decides how to choose the commissioners, how to commission them, how to instruct them, and if necessary, the state legislature can recall them. The convention adopts its own rules, but it starts out with the rule of 1 state, 1 vote. Now, we have now held about 40 conventions of states. The one state, 1 vote rule has been challenged at several conventions unsuccessfully. They have all followed the rule of 1 state, 1 vote, except for a regional meeting which was held in 1889 in St. Louis. And the rule that they adopted there was 1 state, 8 votes. Still interstate equality. Wyoming gets the same say at this convention that California gets. And I will tell you, I find that fact immensely comforting. If the convention then decides whether it wants to propose amendments, if it decides to, it doesn't have to, but if it decides to, it drafts them. If it wants to make recommendations outside of its agenda, it can, but they're not ratifiable proposals. They don't have any legal force. The proposals then go to the states. 38 states, or 3/4, are required to ratify, which is a pretty high barrier, especially when you consider that in every single state, except Brandon's, where are you? Every single state, you'd have to pass not 1 house, but 2 houses. And then finally, all of these rules governing Article 5 can be enforced by the states, they can be enforced by Congress, they can be enforced by the courts. Now, that's usually where I end if I'm just discussing Article 5. At request, I'm adding just very few comments as to why I made the decision to join the Convention of States movement. For 8 years after doing this research, I offered my help to any responsible Article 5 organization, not just ones I necessarily agreed with. Some of you may be familiar with Wolfpack, which is kind of a liberal group. I've helped them out because I believe this is a right, like the right to vote, right? And it has to be available to all citizens. I've helped the BBA people, I've helped the term limits people, and so forth. But I ultimately decided to actually become a senior advisor to the Convention of States for several reasons. Number one, the more the merrier. The more responsible applications state legislatures can pass, the better off we are. Because if there's just one game in town, if the only applications that are approaching 34 are, let's say, the balanced budget amendment, then hostile courts and hostile members of Congress can isolate it. But if there are 4 or 5 applications with widespread support coming down the pike, it might be a little harder for them to mess with us. Secondly, the COS application is an application that can build coalitions. People care about different things. Some people are fiscal hawks. Some people are concerned about the Supreme Court's social issues. Some people are concerned about term limits or whatever. The COS offers an opportunity to unite all of those groups behind a viable but limited application. Thirdly, and this is one that's important to me in particular, the COS application is the only one that gets it to judges. Look, when the Constitution was ratified, the life expectancy, as I mentioned before, not just for women but for men, was a lot less than it is today. The men appointed to the Supreme Court by President Adams and President Washington served an average term on the court of about 8 years. Some of them died, some of them went on to other things. 8 years. Today, the average tenure on the United States Supreme Court is 25 years, and some, like Justice Kennedy, serve over 30. That is skewing the balance between the 3 branches of government. And so I firmly believe we need term limits for the Supreme Court and perhaps for other federal courts as well. Let them have one long term. You get appointed for 14 years or 15 years or even 20. But after that, your time is gone and you go back into the private sector to live under the decisions that you made. The Convention of States application also offers flexibility over time. You know, these campaigns take a long time. The most successful application campaign we ever had, that for direct election of senators, took 14 years. During a period of 14 years or thereabouts, public sentiment ebbs and flows. People become more concerned about one issue sometimes, they become concerned about the budget, then they forget about the budget and they become concerned about something else. But the COS application is broad enough to capture the passion of people, even if it may change. The COS application also avoids legal problems that may trip up other applications. Let me tell you about balanced budget, for example. The people who work in balanced budget are good people, and I'm glad you passed the balanced budget application in the last session. The difficulty they face is that many of these applications don't exactly mirror each other. And if the applications don't mirror each other, that offers an opportunity for hostile Congress or hostile courts to declare they don't aggregate with each other, they don't combine with each other to reach 34. The Convention of States application is a standard one. The operative language is standard. And so they can't raise that argument against it. And then finally, although the COS application is firmly limited, and I want to emphasize that, it's a limited application. The convention that meets under the Convention of States application cannot weaken the Bill of Rights. That's outside the permissible agenda. It cannot meddle with state governments. That's outside the permissible agenda. It cannot meddle with the electoral system. That's outside the permissible agenda. But still it will have enough flexibility to get at some of the root problems of dysfunction. Not just impose a balanced budget amendment or some kind of fiscal restraint, but actually maybe cut back some of the spending powers of the federal government that have created this huge debt. And so that's the reason, those are the reasons, after such a long period of time, I decided to join the COS movement. I'd be happy to take any questions you might have. Yes, sir.
Good evening, guys. My name's Donovan Ferrer. I'm from Gillette. I'm actually in Senator Wasserberg's district, just so you guys know. Anyways, my question, if we were to be able to pass, get a convention like this called, what assurance do we have that, I guess you could say opposing states on the other side of certain issues are not going to turn around and use this convention to pass amendments, that to me would be almost against the original Constitution? How do we
Okay, we've got several different things. First off, as I mentioned, the law of Article 5 is defined by historical practice. Conventions of states have always been limited as to subject matter. And those limits have always been enforced. They can be enforced by the state legislatures because, for example, the state legislatures, if they see things going the wrong way, can call their commissioners home. If the convention, for some reason, decided it was nevertheless going to propose amendments that were outside of its sphere, there's a phrase that we lawyers use, ultra-virus, it's outside their sphere, then Congress can respond by simply saying, we're not going to appoint a mode of ratification for them. They're outside authority. And if Congress were nevertheless to propose a mode of ratification, they then have to go to the same states that authorized the convention to begin with. Now, you think that the state of Wyoming is going to ratify an amendment that it explicitly told its people not to offer? Of course not. And then at every single stage, and you need over 70 state chambers to approve these things. That is an incredibly high bar. If you can't get a few state chambers to block outrageous amendments, we're done for anyway, right? And then finally, you've got the courts and the potential of lawsuits at every single stage. I don't think there's any reasonable possibility of the convention doing too much. My concern, frankly, is the convention may not do enough. It may meet and either not propose an amendment, or maybe not propose enough amendments, or perhaps propose one that's too weak. That's the concern I have. The idea that it's going to go wild is pure fantasy. And again, if you want to look at the precedents and how conventions have actually looked, go to the Article 5 information website, the whole list of conventions there, and you can get the convention journals and look for yourself. Going hog wild is not the way conventions work. In 2016, we had a simulated convention in Williamsburg, Virginia, in which there were 3 commissioners from every state. The overwhelming number of them were state legislators. And they got to work on proposed amendments. And we were all kind of wondering exactly how it would happen, how it would work out. And as we saw these people working and debating with each other on proposed amendments, we said, what do these guys look like? They look like a state legislature. Why is it? Because most of the commissioners are state legislators. They are simply acting like state legislators. They're acting within the agenda, they're acting within the rules. And that is what a convention for proposing amendments is most likely to look like, a state legislature. Yeah?
I suppose the only thing that worries me is that it seems to me as a younger person, we have so many people in these positions now that almost disregard the rules. That's what it comes across to us.
Questions, we have so many people now who like almost disregards the rule, that's what it comes to. If what you're saying is that this country is doomed to anarchy, you know, I'm not sure I can offer that kind of hope. But I don't think we've gone that far. I think people do obey the rules. I think they by and large obey the rules in state legislatures around the country. The state legislatures that are going to be controlling this convention. Let me suggest another possibility. What happens if we don't have a convention? Is there any possibility that Congress is really going to stop our progress or lack of regression to perdition? Virtually no possibility. We have we have 2 runaway conventions in Washington, D.C. One of them is the U.S. Congress, which essentially rewrites the Constitution as it wishes. And the other runaway constitutional convention we have are the 9 justices of the U.S. Supreme Court. That's the alternative. You know, it's not an alternative between this process, which is absolutely safe and nothing can ever go wrong, and someone. The reality is, the only alternative to the convention is we continue on the path we're going.
Professor, we have a question over here. He raised. I'm sorry. He raised his hand, so I walked over this way.
Oh, okay. Is it?
If that's all right.
Okay, I will follow you, Nathan.
Yes, sir.
You control the microphone. Be nice to him. Yes, sir.
Good evening. My question is, here it says that Congress calls the convention by setting time and place. Suppose Congress does not want this convention because they know what it can do. So they say you can have the convention in 2050 in some remote part of the world. What stops them from doing that? And what sets them to say they have to be reasonable? And what's the definition of reasonable?
Okay, well, in the eventuality that Congress would do that, there is something that you can do. Well, first you can go to court, you can ask for writ of mandamus. There is precedent whereby the Supreme Court has ordered Congress to undertake particular actions, even within the scope of Congress's own rules. One famous case involving former Representative Adam Clayton Powell, who was forcibly evicted by Congress in violation of the Constitution. Supreme Court ordered Congress to restore him, and that they did. If Congress, on the other hand, simply takes a position that, and I don't think this is likely, that we're not going to call a convention at all, or we're going to call one for 2050, now we've got an extra constitutional situation. Now we have a true constitutional crisis. And I think Congress would recognize that before taking such an action. Because one thing that the states could then do is hold a convention outside the Constitution. I don't think I would want to go down that road. I don't think Congress would either. That's a very, very remote possibility. Much more realistic possibility. Congress calls the convention for 3 o'clock in the morning on January 1 in Nome, Alaska. Fortunately, conventions have the right to relocate themselves.
Oh, thank you, Professor. I saw someone over here. Yeah.
But that was basically the same question I was asking, which was they're going to call a convention once there's 34 states, but what if they refuse to call a convention? That's what basically what you were answering, right?
Yeah, I was basically answering.
All right, just a couple more questions. Yes, ma'am.
Have there ever been any threats of Article 5 conventions that has forced Congress to act?
Yes, several. Probably the most successful, and I made a kind of an allusion to this. At the end of the 19th century, there was a growing conviction in America that we needed to change the way we chose U.S. senators. I'm not going to go into all the merits of this right now, but various events convinced the American people by overwhelming margins that the election of U.S. senators needed to be transferred from the state legislatures to the people. The state legislatures themselves agreed with this. The House of Representatives passed a constitutional amendment for direct election. The Senate refused to pass it. It died. The House of Representatives passed another resolution for direct election. The Senate refused to pass it. The resolution died. This happened 4 times. The states began an application campaign among themselves. There were in 1912 48 states. You needed 32 states to get a convention. They were at 31 when the Senate said, okay, we were for it all along. And they went ahead and passed it. The second example happened just actually a few years later. It happened early in the 1930s, or late 30s, early 40s. Actually, shortly after that, early 40s. Franklin Roosevelt had just been elected to a 3rd term, breaking the 2-term tradition. So a number of states in the Midwest plus Montana got up an application campaign to limit the president to 2 terms. Congress saw where things were going and responded and proposed the 22nd Amendment, which limited the president to 2 terms. Since that time, however, Congress has gotten more stubborn, or perhaps more arrogant. We've had as many as 32 out of necessary 34 applications for a balanced budget amendment, and Congress has refused to pass one. We also had at one time 33 applications for a convention to propose an amendment to overrule the Supreme Court's reapportionment decisions. But Congress refused to pass it, refused to propose, and it died. I'd like to tell you where the runaway stories, or how the runaway stories became so widely distributed. During the 1960s and 70s, there were a number of conservative amendments proposed that became very popular. One was for a balanced budget amendment. One of those conservative amendments was to reverse the reapportionment decisions. Another was to reverse Roe versus Wade. The liberal establishment went wacko. Academics started writing articles in scholarly journals about how this was a constitutional convention and could run away and could do anything. The New York Times and the Washington Post faithfully spread this. People around the Kennedy family, like Theodore Sorensen, for example, the Kennedy speechwriter, and Arthur Goldberg, President Kennedy's Secretary of Labor, who he later put on the US Supreme Court, and others, used their ability, their media access, to push out this story that an Article 5 convention was a constitutional convention. It scared the heck out of people. And that way they were able to defeat the Balanced Budget Amendment, the Reapportionment Amendment, and the amendment to overturn Roe versus Wade. That's where it came from. One of the most interesting questions is, why is it that conservative groups have bought into this liberal myth? That's for them to answer. But that's where it first became publicized. You know, before the 20th century, nobody ever called an Article 5 convention, nobody ever called it a constitutional convention. I've been all over the founding era record with a fine-tooth comb, all over the record at everything I could find in the 19th century. Nobody ever confused this with a constitutional convention. That was a product of the 20th century by inadvertent error, I think, originally. But then it became part of the mythology due to the power of establishment academics and establishment media. It was a way to suppress people's constitutional right. You remember how they used to suppress the rights of minorities in certain neighborhoods? You know, if you go vote, the sheriff's going to be watching you. All kinds of horrible things are going to happen to you if you vote. And they were able to suppress, notably, the African American vote that way. This runaway convention stuff that the liberal establishment started and some right-wing groups have signed, it's the same thing. It's actually like vote suppression. It's a way of suppressing a key check and balance in the Constitution, and it's a way of suppressing a constitutional right that the founders and people of the United States have given to us. Don't let them do that, please.
Opportunity for another question. Is there someone who has a question you would like to ask? Yes, sir. Mr. Guy.
I've heard people talk about the Congressional Research Service
Yes.
has laid plans supposedly by, I guess, a congressional fiat somehow to say that they would make up the rules. And I don't see anywhere in the Constitution that Congress has anything to do with making up the rules.
Okay. Well, that goes back to that same campaign. I mentioned the establishment liberal campaign. In the 1970s, a Yale law professor named Charles Black wrote an article in the Yale Law Journal in which he said that if a convention is held, Congress should control it using its power under the necessary and proper clause. Now, what's the purpose of this convention mechanism? It's to bypass Congress, right? So if you assume that the necessary and proper clause gives Congress that kind of power, you must be assuming that the founders were total idiots. I would submit that the founders were not idiots, and therefore the necessary and proper clause does not give Congress that power. And in fact, it doesn't. The arguments are technical. I'm not going to get into them tonight. It's getting late. But the fact is the necessary and proper clause does not have that kind of power. Has suggested that the necessary and proper clause can be used. The Congressional Research Service doesn't have all that much credibility. It is a product back before, at one time we didn't have a lot of think tanks in DC. We didn't have the Heritage Foundation or the Brookings Foundation or RAND or so forth. And so the Congressional Research Service was an important resource. It doesn't have that kind of status anymore, so I basically wouldn't worry about it.
I got one more question. I can yell at.
I'm going to let Nathan moderate these questions.
Okay, I'm real curious when you mentioned the 17th Amendment and they changed it from
State
legislators
Right.
sending them to Washington rather than the people voting on them. Isn't it better that the legislators send them to Washington? That's what I've always learned, or been taught. That.
Let's talk about that after it's over.
Okay.
The answer is actually quite complicated. At one time, I would have said unqualifiedly yes, the legislature would have been better. I'm not so sure now, having gone over the historical record, but we can talk about it. I don't think there's a clear yes or no answer. Yes, sir.
I'm curious to know where it stands in terms of the number of states that have submitted this application. Who's next on the list to win over? Just
Wyoming.
What's the count so far?
12, which is actually pretty good. I mean, this organization just got started about 4 years ago. And so 12 represents a little over a third of the way there.
Another question? Let's move your hand. All right. Yes, ma'am.
I had just a couple of days ago given a little presentation on this, and just so you all know, in addition to Wyoming, there are 19 other state legislatures that are considering it in this term. So we're not alone. We've got 20 on the drawing board, if you will. And if, just a few of those come through, if they all come through, we're great. We're just 2 away. But there's a lot of work out there, not just here.
These things tend to move, where you'll get slow, you start off slow and then it gets faster and faster.
Right.
Yes, sir.
Maybe you can address this, and you may not be the spokesperson for conventions of the states. There's been a rumor out there, though, that Convention of States, this organization, has been backed by George Soros or someone for some nefarious purposes, and maybe you could touch on that.
Sure.
Who funds Convention of States?
I don't have access to the funding information. I can only tell you what I know about Article 5 generally. The charge is often made by people on the right that Soros is behind Article 5, and then the charge made by people on the left that the Koch brothers are behind Article 5. Right? Again, I've been working with Article 5 organizations for about 8 years now, well, 7 years now. I have never seen any evidence of either Soros money or Koch money in advocating Article 5. I have seen a lot of evidence of Soros money working against Article 5. For example, one of the leading organizations fighting Article 5 is an organization called the Center on Budget and Policy Priorities. It's based in DC. They have traditionally been funded by Soros, and they are staunchly opposed to Article 5. An even better example, a more lavish recipient of Soros money, is Common Cause. Common Cause is opposing Article 5 everywhere, and they were behind, for example, the rescission resolution in Nevada, whereby Nevada rescinded the BBA resolution. As far as the Koch money is concerned, I wish I'd seen some of it. I mean, basically, the Article 5 Information Center was funded by one individual, a businessman of a moderate wealth, who gave us a grant, and there's never been any additional money at all. I've done all the work essentially for free. And the only grant application I've ever seen to a foundation that was a Koch foundation, that application for Article 5 funding was turned down. So, and I've also been told by people in the Convention of States movement, while I haven't seen the records myself, that there has never been any Soros or, to my knowledge, Koch money either involved in this. So, to me, I think that particular charge, at least with respect to Soros money, is libelous. You know, as a lawyer, I believe it to be libelous, because it's not only false, it's also malicious in the sense that it's been made without any evidence.
The only thing I wanted to mention to you and to everybody here is, across the nation, there's a We the People project in our high schools and in our 5th grades where the kids volunteer to be a part of it, and they debate issues about the Constitution. Mm-hmm. And I would love to see, and I don't know how to get it there, to have this proposed as a topic for the students to debate. So it would be the 5th grade and then the high school project. And they go to Washington if they win state, and they go to nationals in Washington.
A good place to start, where everybody starts for everything these days, is to Google We the People, find out what the contact information is and who's in control of the program, and make a suggestion. That's what I would do.
All right. Yes, sir. Representative.
It's pretty simple, because all the legislators have been getting these emails. Do you know who Jackie Patru is?
No.
And the organization is NPACC.
NPACC. No.
We've all received emails warning us about you. Why an Article 5 convention is dangerous. It was sent today at 2:49.
You know, my mama used to say, by the way, you can tell a lot about a man by his friends and by his enemies. You make the right friends, and you also make apparently the right enemies.
You know, I was.
He's ranting about
when I was younger,
Margaret Thatcher coming to a convention of the states in 1995.
When I was younger, I wish they would have told more women that I was dangerous. Betty, my wife Betty, am I dangerous?
Oh, yeah.
We have one more.
I guess I just wanted to sound a note of caution. I wish I could remember the name of the organization, but I think there's a counterpart to this that I've heard of, and I heard about half of their presentation, and it was kind of stunning and compelling and frightening, where they made the case that there is an entirely unneeded and loaded portion of the government that has racked up enormous debts and unfunded pensions, and really now in the day of modern communications can be completely done away with, and their numbers and their facts, and it was pretty scintillating. And it was the idea of abolishing state governments. So I don't know if you're familiar with that argument that's made. It's almost the direct opposite of what's trying to be achieved here, which is obviously much more respectful of the founder's vision. But are you familiar with that? I just wanted to put people on notice. We can't sit here too long and not get something like this done. So
Yeah,
we agree.
The states have to assert themselves. We doing any more?
Well, I think we've just about wrapped it up. We have maybe time for one more.
One more.
One
Got
more.
it, Nathan.
Anybody else?
One more?
Anybody else? All right, I see over here on the far side.
I'll give you one.
All right. You save yours. Here you go.
So, at our testimony at the hearing in Nebraska, one of the opposition groups, Eagle Forum, she mentions Black's Law Dictionary and their mistaken definition there of the Constitutional Convention. They put Article 5 in there. What's the answer to that?
One of the things you learn about when you go to law school is that Black's Law Dictionary and other legal encyclopedias like American Jurisprudence and Corporate Juris Secundum, they're good places to start, but you never want to end up there. You use those sources as ways for generating cases that help you enter into the field of your research. But the definitions in sources like that are simply not to be relied upon. And a good lawyer doesn't rely upon them. A good lawyer may use them, but recognize their shortcomings. I think one of the reasons why Eagle Forum and sometimes other groups cite Black's Law Dictionary is they don't know anything about the law. Look, it's been absolutely delightful being with you. I'm really happy to be in Wyoming. I just want to thank you very much for the opportunity to talk to you.
Ladies and gentlemen, thank you, If you'll be seated for just a second, I want to we're going to close with this. I want to introduce a few people in the room, but if you'll be seated. So last week I was teaching for 3 days a civics class up in Casper with a group of about 30 kids, and we went through, actually, they asked me to teach on civics, and they said, you take the floor, you teach whatever you want for 3 days. And I thought, oh boy. And so I started off with the Anglo-Saxon common law. We went from 450 AD to 1066. We talked about the Norman invasion and what happened there, and then the reassertion of Anglo-Saxon common law, or a portion of it, under the Magna Carta. We talked about the Petition of Rights and the English Bill of Rights of 1689, and then eventually the Declaration of Independence, and all of that came right out of the work of two individuals, Thomas Jefferson and Lord Acton. And all of these things people understand. Well, I closed with this. I had a rope in the room. I mean, it's Wyoming after all. And so I held one end of that rope, and I'll be honest with you, I picked the smallest girl in the room. And I had her grab the other end of that rope, and I held onto one side, and I said, all right, pull. And obviously she was pulling with everything she could. She had veins popping out of her neck. And I said, hey, you can start whenever you want to. And everybody laughed. I had another small girl come up. But about girl number 5, they started moving me. And I said, let me just teach you about federalism. The federal government's a big giant. And you know what? One state trying to oppose the federal government by itself oftentimes fails. But if we start pulling together, we can restore the vision that was found in our Constitution. And that's what Article 5 does. And there are some folks in this room, not all of them can make it, but they are the ones that are going to be the prime sponsor or co-sponsors of this bill. If you would stand right now, could you stand with me? I see Senator Beitman, let's call him Representative Larson. Thank you for that. Well, thank you so much. And afterward, if you would please just oh yes, I'm so sorry. The Dr. Hallinan is here as well. And thank you so much. I want to thank these gentlemen as we are finishing this evening. But aren't you so glad that this was put on tonight? Rod Guile worked so hard, and Julie Baker. Julie, where are you? Thank you so much. I want you to thank them as well. Thank you so much for coming.